Hello and welcome to BloombergQuint. You're watching the fine print. In April 2014, before coming to power, Prime Minister Narendra Modi had called Aadhaar a political gimmick, emphasizing the security threat it poses. While the law was being debated in the Lok Sabha last year, Finance Minister Arun Jaitley had said, "This bill deals with one primary focus, and that is whoever gets benefited from the Consolidated Fund of India, either state government or the centre and other institutions, the person is entitled to have an Aadhaar card." Both the Prime Minister and the Finance Minister seem to have forgotten their words. Because today not only is Aadhaar ubiquitous, it is less of an entitlement issue but more of a mandatory requirement being thrusted on those who seek to avail of government social welfare schemes. And this despite the Supreme Court's directions that the government cannot make Aadhaar mandatory. So, is the government then in contempt of the Supreme Court's orders? To answer that, I have with me former Additional Solicitor General of India and Senior Advocate Siddharth Luthra. Sir, welcome to the show. In October 2014, the Supreme Court had clarified that the Aadhaar card scheme is purely voluntary and it cannot be made mandatory till the matter is finally decided by the court. It had limited Aadhaar's voluntary use to 6 schemes. But today, from housing subsidy benefits to nutrition programs to farmer welfare schemes to disability benefits, over 25 welfare schemes require Aadhaar enrollment. Would you say that the government is in contempt of the Supreme Court's orders?
In fact, Paiswani, what happened was that the interim order was granted on the 11th of August 2015 and thereafter modified on October 2015 to add 2 more schemes. So the court made it very clear that Aadhaar is not mandatory except for certain specified schemes of the government. If the government then chooses, or officials of the government then choose to insist in making Aadhaar mandatory over and above the orders of the Supreme Court in August 2015 as modified in October 2015, is clearly a breach of the specific directions of the Supreme Court in August 2015, where they said Aadhaar is not to be mandatory except as exempted in terms of the orders. And that being the position, there is breach, and hence consequently it's a case is made out or can be made out for civil contempt.
And can the Supreme Court take cognizance of it by itself, sir?
Well, I think the court could take cognizance of it by itself, but really it needs to be brought to the court's notice as to what's happening. And I'm not aware whether a contempt has or has not been filed. But if an application is filed, I'm confident the court will take a very serious view of it, because when the direction is clear, you're really not allowed to breach the direction flagrantly.
Okay. Has the Supreme Court, sir, to your knowledge, ever held the government in contempt where the government has been in or has acted in violation of a specific direction?
You know, the union is not personally held in contempt, because it is the individual officers who are responsible for ensuring the compliance of the orders of the court, who then, if they were to breach it, they would be held liable in contempt. So if a contempt is to be moved, it's to be moved against specific individuals, those who are responsible for ensuring the compliance, as I said, of the order, and those who have breached that compliance. And that's the point.
Okay. And is it those only who seek to benefit from these social welfare schemes can move the Supreme Court?
Contempt is a jurisdiction where a person finds that there has been a breach of a court's order and comes forward as a relator petitioner, as somebody who relates the act of breach to the court. The contempt jurisdiction is then between the court and the person who's breached the order, and it is really a determination of whether there is a breach or not by the court. So if I may just clarify, anybody who feels that there has been a breach of the court's order and who are affected by it can bring to the court's petition, after moving an appropriate petition, an application for being heard in the pending matter, and submit that there has been a breach and action should be taken. And it is then upon the court to consider the pleas and determine whether action should or should not be taken, and against which specified officers.
Okay, sir, I just want to make one thing clear. There's a cabinet secretariat statement which says that no one will be deprived of the benefits for lack of Aadhaar, and the government has reiterated that till Aadhaar number is assigned to any individual, the benefit will continue to be given based on alternate means of identification. So if the government doesn't deny an individual the benefit but nudges him or her to register with the UIDAI, with the Aadhaar authority, can it still be held in contempt?
I think that's where the grey area comes. Nudging a person to join the Aadhaar scheme because it will lead to certain benefits or otherwise may be an exhortation to somebody to join the Aadhaar, to take an Aadhaar card, but that may strictly not be a breach of the court's order. If, however, you deprive somebody or you insist that without an Aadhaar card, or insist that it must be mandatorily taken, otherwise a person will lose out benefits, now that would be a breach of the court's order, and that would be punishable in the contempt jurisdiction. I think there seems to be a disconnect somewhere, and it clearly needs to be conveyed to the officials who are implementing the cabinet's decision, as also the Supreme Court decision, that there has to be consistency in honoring the Supreme Court decision by all government officials. And the nature of the order passed in August 2015 as modified in October 2015 must be put forth so that, and it must be informed to the common citizens so that people are aware of their rights, and no wing of the government can push through a mandatory Aadhaar when it's not permissible otherwise. So there needs to be some level of clarity. Otherwise, if a petitioner or an individual who's deprived of their rights by virtue of the stand taken that Aadhaar is mandatory, otherwise you will not get your rights, is liable to file a contempt, and then the consequences would follow.
So, sir, are you saying that the notifications itself are a trigger for contempt, or a denial of benefit will trigger contempt?
I think the notification itself would be a trigger for contempt, because the court has said not to make it mandatory, and when the notification is coming in effect seeking to make it mandatory, it is not the effect of the notifications alone but the issuance of the notifications which could give rise to a cause of action for contempt.
So when all of this anyway has to play out before the Supreme Court, it just causes one to wonder that the fervour with which the government is making Aadhaar mandatory, should the Supreme Court not sit up and take notice of the umpteen pending litigations on Aadhaar, whether it is that it being introduced as a money bill, or whether the privacy concerns and now the contempt concerns? Why do you think the Supreme Court is not addressing these issues at the earliest?
Okay. When this matter came up in 2015, a view was taken that it should be placed before a 5 judges bench, a larger bench of the Supreme Court. Now, 5 judges benches are not really easy to constitute because there are a limited number of judges in the Supreme Court, and as you know, we've recently only had another induction of judges in the Supreme Court. Otherwise, the strength was quite limited. But I think it is time for the petitioners to press for an early hearing. I believe they've done it in the past, but now that we have an adequate number of judges, it is time to seek an early hearing and to seek the constitution of a 5 judges bench. I'm given to understand from what I hear in the grapevine in the courts that there are going to be, Aadhaar is likely to be heard in the coming summer vacation. Now, whether that's late or early and whether it's to the satisfaction of the petitioners in that case has to be seen, but that is my understanding, that in this coming summer vacation there are going to be a number of the Constitution bench is going to sit and take up a number of matters.
Okay, let me, sir, request you to then weigh in on some of the pending litigation which I just mentioned, that Aadhaar being introduced as a money bill, the privacy concerns attached with it, because even the authority in one of the press briefings said that they had shut 12 private websites and 12 mobile applications and were on the verge of closing 26 more for illegally obtaining Aadhaar number or enrollment details. So these are the privacy concerns that petitioners have been sort of going to the Supreme Court with. What is your sense on where is this all headed?
Whenever you bring in something like Aadhaar, which is so broad-based and which will have an impact on the rights of the individual, it's a beneficial action, yet it has serious privacy concerns. There ought to be a strong legislative and regulatory framework. Now, since the scale on which Aadhaar is to be done, there would always have been and has been actually a large delegation to the private sector. But the point is, has enough effort been made to make the private sector responsible, both administratively, that is in terms of commercial terms, as also in terms of the regulatory framework? Now, the law came in rather late in this, and as we all know, and therefore there is a legitimate concern, and right now it is being dealt with on an administrative plane. But I think we need a framework. For example, if you're aware of the phone tapping issue, now when phone tapping takes place, there is a direction, and the telecom provider, which is a private sector provider, is put under certain regulations under the telegraph rules, and those regulations are fairly watertight. Now, it's not that there are not going to be breaches, it's not that there are not going to be leaks and consequences in the criminal law, because that's what the law is all about. Criminal law is to prescribe, to give punishments where people breach the law. But the idea is that the regulatory framework must be so effective and strong, coupled with an adequate administrative framework, and the intermeshing of the government overseeing the private players should be such that there is no breach of privacy, and that's what really needs to be brought in place in a situation like this, because Aadhaar is on unprecedented terms, and it requires not only infrastructure from the private sector but a large effort from the government to replicate infrastructure or have adequate infrastructure to oversee what the private sector is doing and how they're going about it.
Sure, I understand, sir. Is it possible for any of the petitioners who are before the Supreme Court already on the matter, or anybody new, to ask the Supreme Court to pass an interim order of some sorts, that till such time all these pending litigations are addressed by the Supreme Court or a detailed hearing is done, then these notifications, which are a cause of concern for people who don't have an Aadhaar card or who don't want to enroll with the authority, can get some sort of a relief?
In October, I think somewhere in, if I'm not mistaken, in 2016, I don't remember the exact month, a similar notification had come out which sought to make Aadhaar mandatory, and the Supreme Court had come down very heavily. And I don't think there's any occasion, if the petitioners were so to choose, to move applications or to press the court to take up the matter. I'm sure the court would be convinced in the available facts to take up the matter and determine whether such notifications are violative of their earlier orders or not.
Well, here's hoping that the Supreme Court addresses all the pending litigation on Aadhaar at the earliest. Thank you, Mr. Luthra, for joining us on the Fine Print, and thank you very much for watching.